Today, I invited a key member of our team. His name is Mike Maloney. Mike, a lot of people have a misconception and a lack of understanding of what estate planning is. Can you shed a light on this matter?
Well, sure, Will. Estate planning, just the words in general, for most people, indicate thoughts of needing to be older and have a lot more money before we would ever venture into estate planning. But I want you to think about this scenario and tell me how many people that you know that this situation affects. And the situation is, imagine if something bad had happened. You got real sick or in a bad accident.
Hmm.
Regardless, you're incapacitated. You can't make financial or medical decisions for yourself. Here are the questions. What documents are not only in place, but even more importantly, all the firms that you do financial business with know about these documents, which are relieving the financial firms of liability for allowing a spouse, adult child, or another trusted family member or friend to have access to your retirement accounts, make a real estate or business transaction, or a medical decision on your behalf. Now, Will, the funny thing is, when I pose that scenario to people, the most common response I receive back from folks is, well, Mike, I've got beneficiaries in all my accounts. And people are surprised to learn that that scenario that I just described has nothing to do with your death. Because unless you die, you don't have beneficiaries. My scenario was you're incapacitated, can't make decisions for yourself. Who has the legal right to access your retirement accounts, conduct real estate or business transactions, or make a medical decision on your behalf? And Will, the answer is no one, unless you've put those instructions in financial or medical powers of attorney or a revocable trust.
Yeah, that's great insight, Mike. I love how you take a very complex matter and simplify it. And there's certain people that already have something in place. How often do you review it, or how do you know you're set up correctly?
Well, here's the interesting thing, Will, from my 3 decades of serving people in this area of planning. I've found that many people that have documents, they've forgotten what those documents actually do. And many people don't necessarily need an update on their documents. They
Hmm.
need a refresher of what the documents are going to do or what benefits they're providing. Okay. Even more importantly, Will, for families that have documents in place, they've named other people to take over and handle their affairs after they're gone or if they're incapacitated. But something that's quite common about the successors we name, our successors have no idea what to do when the time comes.
Hmm.
So, speaking of your question about how often should we update, well, the obvious is we should update when we have a material change to our wishes. And what I mean by that is, do we want a different successor to make our financial and healthcare decisions when we can't? That's a reason to update your planning. Another reason to update planning is you've changed your mind on who's going to get your money and property after you're gone. But if you don't have changes in your successor or your distribution, you don't have to do any updating in your documents. But what I just mentioned moments ago, your successors ought to get educated on what the heck they need to do when it comes time to act for you. Because if they don't know what to do and they get other professionals involved in helping handle your affairs, that's where people can be taken advantage of by a service provider because they have no clue of what process and procedures are in helping a deceased or incapacitated person handle their affairs.
That's great. And Mike, you probably get this a lot. Maybe a couple, elderly couple, they have a house, maybe some qualified accounts, some retirement accounts. but they don't think they need something like that. Do you often come across those type of clients because they feel like they don't have enough money? They're not multimillionaires, let's say.
Sure.
Is that a misconception, or how do you
It's
kind of?
it's a misconception. As I did say earlier, all Americans, especially they hear that those words estate planning.
Mhm.
Almost all of us self-deprivate our own financial situation and say we don't have enough to worry about.
Hmm.
Okay. But the reality is most people's homes today are in the $500,000 plus range. And when we add that up with our financial accounts, although people aren't over and over reviewing that they're millionaires, there are so many people that have $1 million of assets, but because they're not able to spend that kind of money, they don't take possession that they're millionaires. And the reality
Mm.
is they are. And facts are, Will, that Americans that you've described, they absolutely need to have estate planning documents in place, because if they choose not to put their own instructions in place, check this out.
Mhm.
The state that they die in, they'll control where their monies go. And I want to make sure you hear that. People who die with no estate planning documents, they are not leaving their assets and their property to the state of their domicile. What they are allowing is the state of their domicile to direct the distribution of those assets. And I'll give you something that people who are in a second marriage or anywhere past your first marriage and you have children from previous marriages, I
Mhm.
want you to hear something. Those families that I've just described that put zero estate planning documents in place, hear this: the first spouse that passes away and leaves all of the assets to their survivor, when that surviving spouse dies, if they have no documents or instructions in place, all of the assets go down the survivor's bloodline and nothing goes back to that first spouse's child or children
Mm.
that they had in previous marriages. Okay. Something else, Will, you mentioned an older family. Well, how about a family like yours, Will? Young 30s, three children, all minors. Well, let's not make believe that families that look just like yours need documents,
Mm.
because something I found quite common with young families that don't have documents in place, when they decide to go on a kidless vacation,
Hmm.
the night before that kidless vacation, one of the parents, usually mom, is running around the house looking for one of their kids' spiral notebooks. And what they're going to do is they're going to write down instructions for what's supposed to happen to the three children if the worst thing mom and dad could imagine occurs, and that is they die on their vacation.
Mm.
Will, everybody that's hearing this video has got to understand that that piece of paper is nothing. It
Hmm.
does no good. It's not a legal document.
Mhm.
And if mom and dad understood the problems they left behind, none of them would go on vacation again without having the right legal documents that leave the right people in control of not only the children, but being able to handle the money that's left behind for the kids, especially from life insurance contracts, so that those minor children can all stay with one guardian versus being separated, and somebody that the parents trust can control the money.
Hmm.
Because, Will, what I just said to the audience is minor children cannot inherit money. And unless you put proper documents in place, and it's more documents than just the last will and testament. If you die leaving minor children money, you're not going to like the way that they have to house it until they're 18.
Wow.
Okay.
Got it.
So Will, what I've just said is most Americans that not only have some assets, but somebody to care for, they need estate planning documents.
Mhm.
Heck, Will, even people that don't have money and are just starting out in adulthood, I'm talking about an 18-year-old
Mhm.
who's living at home with his parents or her parents. 18-year-olds, if they become incapacitated, and can't make financial or medical decisions, mom and dad are surprised that they have no legal right to make decisions over their adult child. And I
Mm.
said the word adult on purpose because all moms and dads will know that for their 18-year-old, they can't set doctor's appointments for them. The doctor won't tell the parent anything that the 18-year-old and them discussed.
Mm-hmm.
Heck, when the 18-year-old goes off to university, the parents can't even get access to the child's grades unless the child's given them permission to do so.
Mm. So true.
Right? So, will estate planning documents benefit every American 18 years of age or older?
That's so good. And I did want to ask you one last question.
Sure.
Obviously, I'm located in Texas. You're in another state, but we do help clients nationwide.
Yes.
But how does it look like for somebody in California, Texas, or different state? Is it all the same, or can you give us a breakdown of like the different legalities?
Well, I would say that in its simplest, the estate planning issues that people need to address are very similar nationwide. Right? And what are those issues people need to address? They need documents in place to provide succession if they should become incapacitated.
Mhm.
And these succession documents, the purpose is for somebody you trust to handle your money for your benefit. And that's including your spouse. Again, I want to remind everybody, just because you're married to somebody doesn't give you the legal right to make financial or medical decisions for them unless they've given you permission in a document.
Hmm.
Okay. So, incapacitation is an issue that people need to have documents in place to provide succession. That's nationwide. Okay. If people have a desire to avoid probate administration for estates is very similar nationwide.
Hmm.
And what surprises most people is that if you're choosing to use a last will and testament as your estate distribution vehicle, your estate's going to go through probate administration
Hmm.
because that's the process we have in all 50 states to administer a deceased person's instructions that they left behind in their last will and testament. Now, what does differ from state to state is the states you mentioned, California, Texas, Arizona, and 6 others are community property states, and the other 41 states aren't community property states. So there is a difference on whether or not families are using community property law for the taxation of their assets versus English common law for the taxation of their assets. Okay.
Hmm.
So when people receive education, okay, and the education, I'll just go ahead and let everybody know now. For those on the audience, if they desire, they can schedule a time to have a complete estate planning overview or education
Mhm.
where, I don't know, we'll spend 45 minutes to an hour, very casual, and we will show exactly what issues need to be addressed, and we show people how to address them. So after they're educated, they can determine the right planning documents that are going to solve their and their family's planning issues.
So good. So good. Well, thank you so much. And to our audience, again, reach out if you'd like to get more details. My cell phone number is 760-712-5111. My email is will@financialleaders.com, only one L. And reach out so we could arrange a conversation. With that being said, Mike, thank you so much for being here today.
My pleasure, Will.